How do you prepare for a deposition in your case? Let's dive into it. Before I do that, make sure to hit that subscribe button, follow along, where I will make sure your injury case is protected in the future. My name is Ethen Ostroff. I'm a personal injury lawyer, and I have had my hand in, worked on, taken depositions, and plaintiffs just are clients that get a little bit worked up, a little worried about what to expect, what's next, how to prepare for it. I'm going to dive into a few things that'll help ease your anxiety about your upcoming deposition. Let's get into it. So first, what is a deposition? A deposition, in the most basic sense, is a question and answer session under oath. Anything you say under oath at your deposition can be used later at trial. So the first thing I'd kind of tell you is just know this is important, but you will have another chance if your case goes to trial to maybe, correct something you might have misstated at that deposition. Yes, it's important. Yes, it can be read to the jury. Yes, you can be held accountable if you are inconsistent in your answers. But if you make little mistakes, don't stress too much about it. Number two, just relax. Don't stress too much if you get asked a question you were worried to get asked, or if your answer isn't exactly as you hope. The more you seem relaxed and just focus on the answer as opposed to, why did they ask me that question? What are they trying to get at here? Don't stress about it. Keep it to the facts as best as you can, and don't let your emotions get in the way. Number three, don't argue. What I mean by that? Depositions, it's a question and answer session under oath. There's no point to arguing with the person who's asking you questions. You need to understand that it is not personal. They are simply doing their job of asking you questions that their boss is saying they have to ask. Know that if maybe you were at fault for a car accident, or maybe you are not at fault for a car accident, or maybe it's a trip and fall and everybody's contesting who's at fault. The person who appears as a strong, steady witness is more believable than the person who is arguing with every question they're being asked. So my suggestion to you, stick to the facts. Don't argue with the lawyer that is asking you questions. Know that it is not personal. They're just doing their job. And if you focus on the facts, the story will sound and feel better when people like you and don't think you're just causing conflict and slowing things down. Number four, likability is a factor here. I touched on this a little bit before. If the jury likes you, how do they like you? If you seem like you're very confrontational, or every little question you fight, cut and teeth, and every time you're getting asked something, you're getting really upset and worked up. These are things that make you not very likable. If you just focus on answering the question as clean as possible and really just smile a little bit more, answer direct, don't evade questions, you will become more likable. And what gets read to the jury, if your day in trial actually does come, will be easier to digest, and they will like you more, which will be likely more favorable in whatever kind of case that you have if they like you more. Number five, be aware if it's a video or non-video deposition. For example, let's say that you're taking a Zoom deposition and your background looks like shit, and you have people running around and a bird flying in the background and an unmade bed. Be aware if you are on video, that video can be played to the jury later down the line. If it's a virtual deposition, have a professional private room if you can. If you can't do that at home, you should talk to your lawyer about coming to their office or finding a way that they can get you a location that is quiet, secure, good connection, and not a distraction in the background. Or sometimes they actually will bring a videographer to your in-person deposition. If that's the case, you might want to present pretty well. Maybe you want to wear a slightly nicer shirt that day than you might typically. Maybe you want to, comb your hair a little bit more, have a decent shave, whatever you feel like makes you kind of look like your best self. Knowing whether you're on video or not does matter on, I hate to sound shallow, does matter on how you present. Because what they are evaluating during your deposition is how will this person present to a jury down the line. If it's good, that means your value of your case is worth more. And they don't want to put you in front of a jury if you present really well at your deposition. So these things are sort of a snowball effect as your case progresses. And knowing whether you're on video or not will also ease your anxiety on how you need to present physically for your deposition. So lastly, before I let you go, at your deposition, the most important thing you can do, I've said this a couple times now, I'll say it again, just focus on the facts. It's a question and answer session. Leave it at that. It is not personal. It's just a part of the process. And the less you fight, the better you will do. The more you are relaxed, the better you will do. Good luck. Before I let you go, make sure to hit that subscribe button, follow along, where I, Ethen Ostroff, a personal injury lawyer, help thousands of people just like you get the justice they deserve. Thanks so much.